Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Spending a Wednesday afternoon here at the studio, keeping one eye on Major League Baseball playoffs going on right now. But we need to talk yet again about Maryland's assault weapon ban. Now, as you know, we've been doing some serious geeking out around here. Not only went through the petition for certiorari, but went through several of the amicus briefs in support of that petition for certiorari. I wanted to do a video, actually, about what the state of Maryland was arguing as to why the Supreme Court should just ignore this case. Turns out that the state of Maryland has not even filed a response brief yet. And then as it turns out, they actually already got one extension of time. And then it turns out that they're, asking for another extension of time. What the heck's going on here? Well, it's the types of gamesmanship that we should be used to seeing when it comes to cases of this nature. So today, let's spend a few minutes. We'll tell you all what's going on, and let's talk about they're already playing games in the Maryland assault weapon ban case. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Sonoran Desert Institute. That's right, equipping students with the skills and techniques necessary to be successful in the firearms industry. With a faculty which comprises some of the most knowledgeable people in the business with years and years of experience, Sonoran Desert Institute is accredited by the Distance Education Accrediting Commission. And listen, right now they're offering programs that not only give you the options of online experience, but they will give you all the skills necessary to do and allow you to do it with the flexibility of online education. And they got anything that you may be interested in. For example, their Associate of Science in Firearms Technology degree, that's a 60 credit hour course. The Certificate in Firearms Technology and Gunsmithing, that's a 32-hour course. And a Certificate in Firearms Technology Handgun Specialist, a 16-hour course. Listen, if you're ready to start arming yourself with education so that you can make a career in the firearms industry, visit my good friends at Sonoran Desert Institute. You can reach them directly at sdi.edu or call them directly at 480-999-4767. The Sonoran Desert Institute, arming America with education. Okay, America, here's what we're talking about. We're talking about the case of Snope v. Brown. I think a case that we can all agree is immensely important to our inalienable rights. This is a challenge to Maryland's assault weapon ban, a similar ban that is suffered by people in multiple states. This would once and for all definitively answer this question, and we all need this in the worst way. Now, the petitioners in this case, as we know, have already filed for a petition for certiorari before the United States Supreme Court. And we geeked out on that with a video. And then we started going through a bunch of the other amicus videos, especially the ones that decided to take different angles. So we've already done multiple videos about this case without the case even being accepted by the United States Supreme Court. The other day, I went looking around. I was like, I wonder what the state of Maryland's arguing as to why the Supreme Court should ignore it. And lo and behold, when you take a look at the docket, and we'll go ahead and link up the docket down below so you can see it for yourself, you will see that not only has there been a petition filed, but there's actually also been 10 amicus briefs already filed in support of that petition. So there are 11 filings already with the United States Supreme Court in support of this review. The state of Maryland has yet to file its response. They did get one extension of a time, and then lo and behold, they are asking for an additional extension of time. Now, their response is due by October 23rd, and I don't know what day you're going to be seeing this, but there's going to still be plenty of days between the date of that and October 23rd. One would think that, a lot of this stuff seems to be pretty cut and pasted. I've been noticing that because I've been reading way too much of it. But I want you to understand what the Maryland Attorney General is saying here, okay? The petition for writ of certiorari in this case was placed on the court's docket on August 23rd, 2024. The response was initially due September 23rd, 2024, but at respondent's request under Rule 30.4, the time for filing the response was extended 30 days to October 23rd, 2024. Okay, so remember that. The petition here by the plaintiffs has been with the United States Supreme Court and therefore also with the state of Maryland since August 23rd. Okay, what else? Respondents request an additional extension of 30 days so that the response would now be due on or before November 22nd, 2024. The extension is necessary because of the press of other assigned work. Okay, so you're basically telling the Supreme Court, we got other stuff that's more pressing. And I don't know how many other cases they have before the United States Supreme Court, but having appeared in front of courts at different levels, I can assure you that nothing would take more precedent than the actual work you have to get done for the United States Supreme Court. So the letter goes on to further state, notably, undersigned counsel and others associated with this case are involved in significant litigation matters, including the collapse of the Francis Scott Key Bridge in Baltimore. These matters also include other ongoing Second Amendment litigation, including a response to the petition for writ of certiorari in this court in Maryland shall issue Inc. v. Moore, comprehensive litigation challenging sensitive places law in the Fourth Circuit, and a challenge to Maryland's red flag law currently pending in the Supreme Court of Maryland. Well, that certainly does seem that you have an awful lot on your plate, and when you're constantly passing civilian disarmament legislation, this is what happens. Lawsuits pop up. But once again, I would point out that the first in time to the highest court in the land, yeah, it's the Snope case. The letter concludes, the requested extension is necessary to ensure that undersigned counsel and others can devote sufficient attention to those proceedings as well as the responses to the two petitions in this court. Counsel for petitioners oppose this request. Yeah, I bet they do oppose this request, and I likely would as well, because let us not forget that this case kicked around for a couple of years before it sat on the front door of the United States Supreme Court, when it was then GVR'd back down to the Fourth Circuit 2 summers ago. That's right, the same summer as Bruin. Shortly thereafter, it gets kicked back down to the Fourth Circuit. Then remember, it festers around there for a while. Then a 3-judge panel hears it, and for whatever reason, they don't issue a ruling for over a year. And then without a ruling ever being issued, the full en banc panel just decides sua sponte, hey, let's just suck it up and take it ourselves, which they do. They screw it all up. They issue an absolutely horrific ruling. So as you can see, this case hasn't really aged like fine wine. It's aged more like milk. And I can see why the petitioners are absolutely ready to get the ball rolling on this. And candidly, the Supreme Court has filled most of its docket for the upcoming term, which has already started. So if we're going to get an answer on this sometime in the next 12 months, this case needs to be slated for argument sometime in the spring. Okay, the case once again is Snope v. Brown. It was originally called Bianchi v. Frosch, then called Bianchi v. Brown. Now we're calling it Snope v. Brown. Listen, we'll go ahead and link it all up down below so that you guys can geek out on it for yourself. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video that we should be doing around here, go ahead and tell us by clicking on that link right there and letting us know. It's probably going to be better than any idea we come up with. If you just want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box as well. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.